We are excited about today because it is our first live webinar on this important labor and employment training topic. And so we are excited for everyone to join us today. My name is Isaiah Green, and I serve as CalOSBA for short, California Office of the Small Business Advocates, Central California Regional Advisor, Assistant Deputy Director here in Fresno, California, serving over about 19 counties within the Central Valley and all throughout the state. And our goal is to support all 4.2 million small businesses to access to resources, information, knowledge, and of course, yes, capital. And so very excited today to be able to work alongside of some of our great partners, the California Chamber of Commerce and the Small Business Policy Council, with one of my favorites. She just has a wealth of knowledge, Bianca Saad, who is going to just inform us today, which it seems like this is a hot topic, seeking and hiring employees. And so excited today. A few housekeeping rules. We are going to allow questions towards the end of the presentation, but if you have a question, and you feel free to put it in the Q&A box. If Bianca decides to answer it just with her flow, she will answer it in between some of her transitions. But again, we will leave some time towards the end of the presentation to answer the questions that you may have. And so with that being said, Bianca, I'm going to pass the baton to you. Excited to learn more today.
Thank you so much, Isaiah, for that wonderful introduction. And good morning, everybody. Thanks so much for being with us here live. We're very excited for this first live in our series. So although I am an attorney, of course, that means I need to give some disclaimers before we get started. Just a reminder that nothing in the presentation should be relied upon as legal advice. You may have specific questions, specific to your workplace that might be better suited for you to consult with counsel about. And as we address questions, you may hear me mention that because again, we're here today to talk at a very high level around recruiting and hiring. Also, just a reminder that the contents of the presentation are current as of the date of the presentation. So for those of you who are reviewing the recording later on, just keep that in mind. As we know, things can evolve very quickly in the world of employment law. So, again, just keep that in mind as you review going back. And then lastly, the presentation may not be recorded, duplicated, or distributed either in whole or in part without written consent from CalChamber and CalOSBA. All right, so today's topic is recruiting and hiring new employees. So this is, a very important topic. If you are, fortunate enough to be in that place where your business is growing, or maybe you just need to replace some positions that have, need to be filled, there's a lot to know, especially in California, around this process. So we have a jam-packed agenda, again, very high level. I'm going to try to really just highlight some things for you. I'm not at all going in on a deep level on all of these things, but giving you enough to, sometimes in this world, it's like you don't know what you don't know. And so our job and goal today is really to make you aware of the things to be aware of with some basic information. And then, you'll be able to dig in additionally, as you need according to your business's needs. So with that, we're going to talk about first job postings and interviews. So what do we need to think about when we're advertising for a position? What do we need to be aware of for the interview process? Once we have that candidate, what that we know we want, what are the criminal background checks if we're going to engage in those? We have certain rules around criminal background checks and then other pre-employment screenings. Again, not necessarily exhaustive in the land of screenings, but the heavy hitters, if you will, that we might see in the hiring space. And then we'll talk about some of the required forms and documentation. There is a lot of paperwork that is involved when you're hiring a new employee, and just a couple of important reminders around onboarding so that your employee can really hit the ground running and feel successful in their role. So getting them off to that solid start. And then we're going to round it out with key takeaways and reminders. So that is the overview of where we're going to be going this morning. So let's get into the job postings and interviews. So before we even talk about the job postings, actually the job description is the starting place that we're going to be thinking about. So the job description is really important when we're looking at the entire employment life cycle, from hiring and throughout. The job description is always going to be there for that role. If we're eventually needing to be in the space of whether or not we need to provide somebody a reasonable accommodation, the job description is going to be relevant. So it's always going to be important for us to have an accurate, up-to-date job description that reflects what the job is that's going to be performed. So if we're creating a new role, then that's great. We want to make sure that we do our best in terms of, doing our best at that point as a starting point. What is this individual going to be doing, and is it accurately reflected in the job description? If we're filling a position that maybe was held by an individual for a very long period of time, that's a good time for us to pull it back out, get the dust off, and say, ask ourselves, is this accurate, or have there been changes in terms of how this role has evolved? So we want to either be creating it or updating it. And the job descriptions, again, we want those in writing. We want them to clearly define the essential functions of the job. That is an important piece for any job description, again, because when we get into things around accommodation, whether it's disability accommodation or reasonable accommodation around religion, we need to know what are the essential functions of the job, because individuals are entitled to a reasonable accommodation if they can perform the essential functions, with that reasonable accommodation. So, and then of course, just including the overall scope and nature of the role, right? Describing what is entailed for this position. Along those lines, we want to identify, are there any physical and mental demands? Are there any particular educational prerequisites and experience that is required? And then we, of course, have this note here about avoiding the use of generic job descriptions. Again, for all the reasons that I've just stated, we really want this to accurately reflect as best to our ability what this role is going to entail. So yes, you could go out online and easily find a generic job description for any, enter any position. You're going to get something back up. And that might serve as a reasonable starting point for you. But again, you want to make sure that it's really reflecting what's going to be happening in that role for your particular business. All right. So once we've got that job description, we've, revised it, updated it, we made sure that it fits our needs. That's going to provide us, that's going to serve as the foundation really for our job posting. So this is how we're getting the word out about the position. How are we letting potential applicants know about the job? Now, there are some things that we have to be very mindful of when it comes to job postings. And so that goes into, of course, in the employment life cycle, again, for all aspects of employment, and this includes for applicants, but also throughout, once somebody is your employee, we of course have discrimination protections and harassment, retaliation. So when it comes to discrimination, we of course cannot make any hiring decisions based on somebody's protected class, for example. And so we want to make sure that when it comes to the language that we have in our job postings, that we're not including any kind of language that would be perceived as discriminatory or in favor of a particular protected class. So for example, you would want to avoid a term like waitress, right? That is specific to sex and gender. We would want to use something that's gender neutral so that we're not that it's not targeting and favoring a particular class. Same thing with the reference like digital native. Digital native is a term that we have seen come out, referring to those babies that were born with iPhones in their hand, right? They've been here, with the smartphones, and it's there. All of these things come very naturally to them because they've grown up with them. Well, if you're targeting a digital native as somebody who you want to be as an applicant that is desirable to you, then what is that saying about somebody who is, above the age of 40, which is the protected class? So we have to make sure that we're not using any terminology that would unintentionally exclude individuals based on those protected classes. We also want to avoid blanket statements that only employees available on certain weekend days or evenings would be considered. Reason being here is this could possibly screen out employees by their religious creed. So again, we want to, we have concepts like reasonable accommodation for religious creed, and that requires an interactive process. So it's not just a blanket disqualification for employment, in other words. So we don't want to have blanket language that would discourage those individuals from applying. All right, a couple of other notes around job postings. So we want to avoid terms like long-term commitment in a posting, saying that we're seeking, an applicant for somebody to, be with us for a long time, or any kind of long-term commitment. This could go against the nature of the at-will relationship that is in California, and would create an implied contract. So let me explain that a little bit. California is what is referred to as an at-will state when it comes to employment, meaning that with the employment relationship, the employer or the employee can end the relationship at any time for any reason. Now, of course, there's a big caveat to that. It cannot be an illegal reason, right? And especially in California, we have many protections around termination. So there could be a lot of reasons that somebody could potentially be unlawfully terminated. But outside of that, right, we have this at-will relationship, meaning an employer doesn't have to establish good cause to justify a termination. So we want to stay away from any language that's going to erode at that at-will relationship that comes with California. Now, some pay scale requirements that we have had in place for the last couple of years to be aware of. If you are an employer with 15 or more employees, then you do need to provide pay scale information on your job posting. And that is the salary or hourly wage range that you reasonably expect to pay for that position. This is true even if you're using a third party to post it, right? You as the employer, it's the job that you're seeking out, you need to include that information. Now, even if you're a smaller business and you have fewer than 15 employees, you still need to provide this range if it's requested by an applicant. So keep that in mind. So going back to really when you're thinking about a role that you need to fill, probably alongside the job description, you should be thinking about what is the pay scale? What is the range that we're willing to pay for this position? And we should know that whether we have to post it or not, because applicants have the ability to ask for it. Also, when it comes to another area of blanket language that we want to stay away from, criminal history. We don't want to have any blanket language that criminal history is going to disqualify an individual. This is because of the very strict ban the box rules and the fair chance process. We're going to be talking about that here in a little bit. You can discuss the fact that applicants will be subject to pre-employment screening, such as criminal background, right? But we're not saying somebody who has a criminal history is excluded or disqualified. That goes against the entire law that we're going to talk about, and so you want to stay away from any blanket language of that nature. And then just a reminder for those of you who had the ability to check out our first episode in the series about new laws for 2025. So this is new around driver's licenses in job ads, that we should only be mentioning these if the driving is reasonably expected to be one of the job duties and there isn't any comparable alternative means for transportation. So meaning we need the driving is one of the job duties, and it would not be reasonable or comparable in terms of the time or the expense to the employer for them to, say, utilize things like public transportation, biking, walking, then if that's the case, we can include it, but something we need to be aware of and make sure that we're justified in including that driver's license provision on the job posting. All right. So now that we've talked about the job postings and you've gotten your posting, your job, ad out there essentially, let's talk about job applications and how this is really actually not normally viewed as, but can be considered really part of the first part of the interview process, right? That's going to be the world in which we're weeding through the applications or the resumes. If we're using applications, then we're essentially asking them questions, right? We're requesting information from them related to the job. And so that means that we do need to be mindful of what is on our job application. This is another area where, I would really caution against just pulling out a template job application from the internet and using it without any kind of review or modification, because California, again, is very specific about what we can and cannot ask on applications, and even more protective than other states. So like if you're a multi-state employer, you may have an application that's okay in another state that you would not be utilizing here in California. So we can't seek information, again, about protected classes. So we're not asking for them for things like date of birth, their sex, their marital status, immigration status, criminal history. All of these things we have to stay away from in the application. The work availability, I did mention this before in terms of as in the context of job postings, but it carries over into the job application, which is if we're asking them, what is your work availability? Is there any unavailability that you need to indicate? You have to be specific in the application to let them know we are not asking about unavailability that is related to religious or disability needs. Again, this is really important because otherwise we could be screening individuals out based on that protected status. And if it comes to our attention once they're hired that they do have a window of unavailability, let's say due to religion, then we have to engage in the interactive process and determine a reasonable accommodation for that. But it's not going to disqualify them for the position. So that's really important to be aware of. And then lastly, we cannot in California ask about prior salary history. So again, this is where, just relying on any old template could get you into trouble because, those that are coming from way back in the day, I remember in my first days of applying for jobs, it was very common, right, that we would see your work history, your job, what was your amount of pay for that. We cannot ask salary history in any form or fashion, not in the job application, not in the interview. So we need to make sure that we don't have we're not asking that information on the application. All right, so then once we get to the interview process, which means we've, presumably we've received a batch of applications or resumes, we've maybe narrowed it down to a few candidates that we'd like to have further discussion with. And so let's talk about how to prepare for that. As I mentioned already, anything that you're prohibited from asking for on the job application, you're also going to be prohibited from asking in the interview. So we want to make sure that if it's just us conducting the interview because we're still a small shop, or if we have some managers that are helping us, whoever's involved in the interview process needs to be trained and aware of what things that they should not be asking. So it's really easy in the interview process to ask for things we shouldn't be asking, and I'll get to that in a moment. But of course, we're interviewing somebody. We want to establish a rapport with them. We want to be friendly and get to know them, right? And just have that sort of friendly conversation. But we have to stay away from asking about certain things like their current family life or their family history, outside activities or hobbies, their language fluency, even education, right? If we're asking them about things like their graduation year, that's problematic. because that's getting to their age. And then, as I mentioned, the salary or criminal history. Again, seemingly innocent things, right? What do you like to do outside of work? What's your, what are your hobbies? Well, something like that could, maybe they volunteer with their church or an organization that is tied to their national origin. I mean, you just never know. And we really want to keep our questions tied to the job itself. So that's where we're going to use the job description to outline those interview questions and help us to make sure that the questions that we're asking are really focusing on the job duties and the business necessity. So once we, again, are in that interview process, hopefully we would have had that job description to form the basis of that outline for, that we'll use for all of our candidates. When you are interviewing, consistency is going to be key. So having the same, handful of open-ended questions that you're going to ask of each candidate. Now, of course, based on their answers, which will vary, you may go along different trails and ask different follow-up questions, and that's perfectly fine. But as far as, your list to start is what you're asking for, you'll want to be consistent and, again, open-ended to allow the candidate to provide to you, right, a sense of how they're qualified for the position, the skills as they relate to the position. You can ask things, again, about their processes that they would take. So for example, explain in detailed steps how you would accomplish this particular task, and then allowing them to elaborate on that. And then just a note for interviews that avoid any shorthand notes that wouldn't be understandable in terms of if they were ever to be reviewed going back, if if there's like a failure to hire claim that you might be subject to. And we do have record keeping obligations. So just keep that in mind. And then also too, definitely you don't want to be writing notes about, again, things of their protected classes. Let's say, for example, if you're just trying to keep track of who's who, that could be a problem, right? If somebody's going back later and they're seeing, oh, well, this hiring manager is noting, of protected classes, and then they end up in a pile of individuals who maybe weren't hired. So, you just never know how that things can be misinterpreted. So you want to keep that in mind when it comes to note taking. Okay, so we've gone through the interview process. We've narrowed it down, and we think we now have our top candidate whom we'd like to make an offer. So how do we go about this, and what is legally required? So let's talk about offer letters. Offer letters are not legally required. However, they really are going to be a best practice, particularly if we are engaging in any sort of pre-employment screening, such as a criminal background check, drug testing, or medical exams, because that's basically laying out the contingent nature of the offer, right? This is where this offer is contingent upon the successful completion of XYZ conditions. It could even be successful completion of reference checks. So we're not going to go into detail here, but that is still another reference checks. There aren't specific timing requirements. We just want to make sure we have their authorization, of course, to do those. So what would an offer letter contain if we're going to be using one of those? So remember that at-will statement, just to reiterate the at-will nature of the employment, their wages or salary information that they're going to be earning, tied to, for example, whether they're going to be a non-exempt, that is an hourly employee, and what is their hourly rate, or if they are qualified as an exempt employee, then what is their salary going to be? And then what is the date, and I would even say tentative date, that the prospective employee is expected to work. Again, because we want to make sure that all of the contingencies are met before that offer takes effect and before they start their employment, such as a successful criminal background check or a drug test. And if for some reason something gets delayed, we want just them to know that that date could potentially be pushed out, because you really do want to make sure that you have those boxes checked before they start and are starting their employment with you. Okay. So let's see. It looks like we have a question about, before we move on to criminal background checks for interviews, if somebody discloses their current salary, can you make a note of it? Yeah, so great question. We do sometimes have where individuals are voluntarily disclosing it. However, you still need to exercise caution around like utilizing that as the basis of how you're going to pay them, right? If you end up making them an offer. So you still have to really exercise caution because the whole concept behind why we're not getting that prior salary is that we're trying to close this gap with any pay gaps that there may be in positions due to gender or race. And so we want to make sure that we're not perpetuating that by if somebody was earning less in a role prior to coming here, right? And then that is used as justification for putting them on the lower end of the scale, whereas somebody else maybe you would be offering more. So you still need to be careful around that. And again, this is where you go into it knowing what the range that you're working with is. And then of course what you ultimately offer should be based upon their skills and their experience and things of that nature. Okay, and then we have another question around the offer letter and whether that needs to include a job title and reporting manager. Again, because the offer letter is not something that is legally required, there is no, for example, required list of what needs to be included. But I think that's great to have, right? The job title, absolutely. And who they're reporting to. Really, it's that you can certainly include that information for the applicant. All right, so then I think we're going to keep rolling now into our criminal background checks and other employment screenings. And then, of course, if we still have more questions toward the end, we'll have time to address as far as any of the topics that we're covering today. Okay, so criminal background checks, before we get into sort of the rules of the road, if you will, around criminal background checks, and specifically the ban the box rules that we're going to be talking about, just a note that if you are an employer who is actually required by law to conduct a background check, then you're sort of separate from any of this and what we're talking about, right? You have the ability to do that before extending the job offer, and you aren't required to follow those ban the box rules. If you're required by law, presumably you would know if you fall into that category. But outside of that, if you are, let's say you're just, again, because conducting a criminal background check, it's not legally required. However, it could be a good practice, right? Depending on the nature of your business or the specific job duties once that conditional offer is made. So if you are going to conduct background checks, then there are very specific rules and a specific process that we need to follow, again, to make sure that we are not running afoul of ban the box. And then also we'll talk about what the fair chance process specifically looks like. So first thing to note is with background checks, they have to be authorized by the applicant. And so we do have some notice requirements that we have to provide to them at the federal level as well as at California. So we have the Federal Fair Credit Reporting Act, or sometimes referred to as FCRA, and then the California Investigative Consumer Reporting Agency Act, or ICRA is sometimes how it's described. And these are both separate notices. They cannot be combined. We need to make sure, again, that we're getting that authorization and providing these notices before we conduct the criminal background check. And remember, the criminal background check isn't happening until we know this is the person we want to hire, right? We're not just conducting this on any applicant at any time. Now, when we're working, if we're working with a vendor, let's say, to get that criminal background information, we should make sure that they are California compliant. They understand, again, because California has several protections and limitations that may not exist in other states. And so first and foremost, there's always going to be certain criminal information that's just simply off limits. It cannot be considered at all. So things like arrests or detentions that don't result in a conviction, information that's related to a referral to or participation in a criminal diversion program, convictions for most marijuana possession offenses more than 2 years old, and judicially expunged, sealed, or dismissed convictions, or juvenile criminal history. Now, there are some exceptions for peace officers and certain healthcare employees, but generally speaking, all of this is going to be off limits. So we shouldn't be seeing any of that information. So now we're going to talk about, okay, if we're an employer and we're conducting a criminal background check and something, what are the rules that we need to be aware of if we're going to be utilizing criminal background checks? So first and foremost, the ban the box laws that we're talking about right now. These apply to employers with 5 or more employees. And so if you have 5 or more employees, you're conducting criminal background check. Again, you're not required by law to do it based on your industry or anything that's specifying that requirement. Then this is the world that we're going to be working in. And so the timing is really important, right? So we make that offer of employment. That's contingent upon the successful criminal background check. We are not discussing, remember, criminal history anytime prior to this. So we're not asking about it on the application. We're not asking them about it in the interview process. We can certainly say, yes, this job requires, successful criminal history, but we can't, again, have any kind of blanket language that talks about, somebody being excluded or things of that nature. We need to make sure, again, we're providing their authorization, providing the required notices. And then this is where it's really important is if there is criminal history that comes back to us, then we have to engage in what is referred to as the fair chance process regarding that history before revoking the employment offer. So in other words, just the fact that somebody's history comes back and actually has something on it is not clean, is another way to describe it, doesn't mean that, okay, now we don't have to give them the job. The inquiry does not at all end there. Before we revoke an employment offer for an applicant, again, based on that adverse criminal history report, again, we have to go through what's referred to as this fair chance process. So what does that mean? Well, we have to conduct an individualized assessment of that report or that conviction, right? And so we'll talk more about that in a moment, but really, essentially, we're looking at what is the conviction, how does it relate to the job that we need them to do, and how does this conviction go against that and put us at, in jeopardy if we were to hire them, that would essentially justify us revoking the offer. Even if we come to that determination after going through that individualized assessment, we have to provide what's referred to as a preliminary written notice of revocation of that offer. And it's preliminary because we have to allow the applicant the opportunity to respond. Sometimes this can actually just be an identity issue where somebody with the same name has come up, and that's going to allow that applicant to clear that up, or it's going to allow them to share things like other mitigating circumstances around the conviction itself, letters of reference. I mean, it can be all sorts of things in terms of their side of the story. What is that additional information? Employers are indeed required to consider any additional information that applicant provides before giving that final written notice of revocation. If, so they get that additional information from the applicant, then they still have to look at that and ask themselves the question, right? Is this person still going to be disqualified such that we need to revoke the offer? And if so, we need to provide a final written notice to them. So when we're talking about this process, it applies to all applicants, which includes our outside and internal candidates for the position. as well as any new hires that have been allowed to work pending their criminal history background. Again, not an ideal situation. I would say avoid that if you can. Sometimes it may be unavoidable if for some reason there's a delay and we really need somebody in that position. But just know if they are technically already your employee and then you get that criminal history background back, we still need to go through this process before terminating their employment as a result. So I mentioned that individualized assessment, and this is where, again, we're really looking at, does this conviction have a direct and adverse relationship to the specific job duties? So we need to consider things like the nature and the gravity of the offense, the time that has passed since the offense, and the nature of the job sought or held. So for example, if somebody comes back with a DUI conviction, this is the classic example that we use a lot, a DUI conviction, and let's say the position is for a filing clerk or a receptionist, somebody who's in the office, we're never needing to rely on them to do any driving for work. They are there, they're answering phones, they're doing paperwork, and that's pretty much their job. Is that, does that DUI conviction really impact and have a significant adverse relationship to those specific job duties? Contrast that with a DUI conviction or maybe multiple with somebody who driving is the job and that's all they're doing is they're on the road, right? That would be much more concerning. Regardless of the position and the conviction, you still have to go through that individualized assessment. There's never going to be any blanket, where it's a conviction is just bad enough in and of itself to say, okay, we're revoking the offer. Now, there's no requirement that the assessment is written, but you can certainly, again, document your reasons for revoking the offer. And I would recommend that, again, because you may be in a position, if you're having to defend your decision for revoking the offer, that's going to, assist you. Okay, so back to the general category of pre-employment screening. So that has, we just kind of ran through, again, very high level in terms of the criminal background rules and the timing that we need to be aware of. So let's talk about pre-employment drug testing. Again, I'm referring in this context, I recognize there are certain industries and things that are required, things like DOT, Department of Transportation, they have their own set of rules. But if we're just a business and as a business practice, we think it's a good idea based on, again, the nature of the position, our industry, things like that, that we are going to conduct pre-employment drug testing, we certainly can. Just some things to keep in mind. This is also going to happen post-offer pre-employment. So again, this is the person we want to hire. We're not just sending off our applicants to drug testing. It's not until we know that's the one for the job. And we're going to let them know that in that offer letter to, that it's contingent upon passing the test. So if somebody decides that they don't want to take it, they just simply refuse it, or if they fail the test, then we can decline to hire them. Now, something to be aware of in California is that we can't discriminate against applicants and employees for the use of cannabis if that use is off-duty and away from the workplace. So what does that mean for testing? Well, it doesn't mean that we can't test for cannabis. We absolutely can, but how we test has now had to change. And so if you are conducting pre-employment drug testing, again, you'll want to make sure that your vendor is aware that you're, is aware of this, the lab that you're using, that they're confirmed that they're compliant with this rule, that we cannot test in a way that screens for non-psychoactive cannabis metabolites. That is a mouthful. It sounds very scientific, but basically the best way I know how to explain it is cannabis can stay in your one system for a long time. So let's say somebody ingested some sort of an edible, that would stay in their system, right, long beyond them being actually impaired from it. So could be a week later, 2 weeks later. They're clearly not impaired from the cannabis, but testing, certain tests would still pick that up and then disqualify them. So we just need to make sure that we're testing in a way that isn't screening for those non-psychoactive cannabis metabolites. Now, the thing to know too about pre-employment drug testing, it is a good place to do it because once somebody becomes our employee, our ability to drug test is much more limited. We can't just, as we decide, say, hey, let's just go have all of our staff be subject to drug testing. Okay. Again, unless you're in some specific industry, things like that, like the general rule is we're not randomly drug testing folks. And so once they become our employee, we're really subject to a higher standard, which is we have a reasonable suspicion that an employee is actually under the influence before subjecting them to any sort of drug testing. So just something to keep in mind if you're evaluating whether or not, pre-employment drug testing is something you want to do. All right, and then medical exams, we can do these. Again, the timing is important. It's post-offer pre-employment. The purpose does need to be limited to determining fitness for the job in question, and the exam needs to be related, job-related and consistent with business necessity. We also want to make sure that all of our entering employees for that same position are subjected to the same exam, right? So we're not, for example, just targeting one individual who we interviewed because we noticed they were, walking a little more slowly, and we want to make sure that that particular individual can really do the job and we're not subjecting anybody else. It has to be, again, it's job related, business related to business necessity, consistent with that, and we're consistent across the board in terms of everybody in that position. So this is, again, where our job description is going to be our friend, because that job description and they're, looking at what are the duties, that's going to determine the job relatedness and the necessity for the medical exam. Not every position is going to require a medical exam. And if you're ever unclear about whether or not a medical exam is appropriate for a certain position, that is another place I would flag and say that's great to have it reviewed by legal counsel. But if you are in that lane of medical exams, then your doctor is actually going to be the one that makes that determination. And then the applicant would be entitled to a second opinion before being disqualified for the job. This last slide is just flagging some other pre-employment screenings and exams. So a note on credit checks that these are generally going to be prohibited. So talking about, consumer credit report, pulling that for employment purposes. There are limited exceptions under the labor code for certain types of positions. So managerial positions, somebody who has regular access to, personal financial information, things like bank or credit card information, social security number, date of birth, right? And that's different from somebody who's just regularly handling credit cards for payment, right? Such as the cashier. That's not what we're talking about, but maybe like a loan officer, somebody who, again, has regular access to that. Or it could also include, for example, somebody who is authorized to sign for financial statements on the company's behalf. Those are the types of things that would warrant a credit check. So again, if you're using those, you just want to make sure you're falling under one of those limited exceptions. All right, and then what about psychological exams and personality tests? So psychological exams, these are rarely allowed. You have to show a compelling interest that outweighs the applicant's right to privacy. Aside from privacy violations that we have to be worried about, we also would potentially violate the Americans with Disabilities Act and the Fair Employment and Housing Act in California. So definitely want to consult legal counsel. And then personality tests, and these may seem a little less harmful, I guess, or less intrusive. However, and they're not outright prohibited, but again, they could still raise issues around bias, discrimination. It could implicate protected characteristics or could even be considered as functioning as a pre-offer medical exam. So again, exercise caution. I would say consult legal counsel prior to the use of those as well. All right. In the interest of time, I'm just going to keep rolling, and then I'll make sure we have some time at the end for questions. So now let's talk about hiring forms and documentation. So again, highlighting some of the heavy hitters in terms of what those pre-employment screenings are. Let's assume that your candidate passed all of those very successfully, and now you're ready to bring them on board. What are all of the things that we need to make sure that we have in place for them once we are, bringing on that new employee? There's a lot of paperwork. I will say that. And so we have our, of course, federal and state tax forms. We have our Form I-9. Remember, that's to, to confirm that they're authorized to work in the United States. Required pamphlets and notices. California has a lot of them. We have workers' compensation, state disability insurance, paid family leave, sexual harassment. We also have a domestic violence and stalking notice. You will also have to submit your new employees report form to the EDD. And then employers are required to have a harassment, discrimination, and retaliation prevention policy. You'll want to make sure that you do get a confirmation of receipt of this. And we also in California do have to provide a lactation accommodation policy to all of our employees upon hire. Some other tasks that could apply, maybe not across the board. Again, some workers, maybe not others, again, depending on your workforce. We have what's referred to often as a wage theft notice. This is the notice under Labor Code Section 2810.5. And this is a notice to our non-exempt employees. There's a lot of important information that we need to include, and this is definitely going to be required for our non-exempt employees. So it's going to include their hourly rate. If they have multiple hourly rates, if they're getting different hourly rates for different duties, we need to have all of those rates of pay. It also includes information around how we're providing and meeting our California paid sick leave obligations. There's other information on there. Again, very important that we get that to our non-exempt employees upon hire. We also have, a lot of health benefits and employee selection paperwork that you see referenced there, as well as employee handbook review and acknowledgement. This is if you provide a handbook. We'll touch on that more in a moment. If you're hiring minors, verifying minors' permit to work, safety training, emergency contact information, property return agreements, an arbitration agreement. Again, you may or may not have one of those. Definitely not something that you want to explore on your own, right? Hopefully you're doing so with the assistance of legal counsel. Again, not a topic we're covering today, but I'll just say this, that arbitration agreements and the validity of them is regularly challenged by employees. So you just want to, and the law is always changing. In California, we get cases regularly around arbitration. So you want to make sure that you're utilizing legal counsel and that it's meeting your needs if you're going to have one of those. And then lastly, with all of these new hire tasks, things like, completing the paperwork, reviewing the handbook, any kind of administrative paperwork, forms, things like that, all of this is going to be considered hours worked for purposes of pay. So it means we do need to pay our employees for this time, even if we send some of the forms for them to fill out in advance of their official first day. And in fact, we like to encourage folks really just let them come to their first day, and let's know that a big chunk of that is going to be dedicated to these administrative tasks and the paperwork so that we can ensure that they are properly being paid, as opposed to trying to send things out in advance with the idea of, so they can really just hit the ground running on their actual work. Try to avoid that temptation if you can. Again, it's going to be less risky in terms of you unintentionally having unpaid time for them conducting work for you. So what are some other onboarding, areas for onboarding success? So we mentioned the handbook as potentially one of those other areas. Again, that's because handbooks are not legally required. So employers don't have to have an employee handbook. However, they are a recommended best practice. They're going to provide employees with really just the lay of the land for you, right? What are the guidelines? What are the expectations? Our policies and procedures? In California, we have many, many leaves, for example, some that are subject to all employers, regardless of size, some that are only subject to, covering employers who are larger. But we need to get that information out to our employees in terms of who to ask if they need a particular type of leave. It's also going to demonstrate our compliance with the law. So it can help us defend against legal claims down the road if we're in that situation. And we want to provide it, on that first day, if possible, giving them, again, that time to review it in detail, having the ability to ask, the contact person, whoever's they're supposed to be asking, if they have questions, giving them the opportunity to do all that before signing their acknowledgments is really going to set them up for success. And again, make sure that there's no surprises on their end. So just some other reminders about onboarding that, aside from all of the required paperwork and things of that nature that, yes, we do have to do as employers, is remembering that really this first day is the new hire's first impression. So we want to have a plan in place for how we're going to cover their first day of work. Again, this is going to likely include a lot of sort of the maybe more considered boring or administrative items before they can really get into the meat and potatoes of their position, things like going over their job description, the handbook review and acknowledgement. But it's still all really important, right? Things like meeting their team, if giving them a tour of the workplace, required training. Don't forget, in California, we have harassment prevention training requirements that we need to meet within 6 months of hire. That's something you could just plan to knock out, again, right out the gate, so you don't have to worry about tracking that deadline. And again, having the time for all of that new hire paperwork, remembering that, yes, they should be on the clock and paid for all of those onboarding activities, even though it doesn't feel like it's productive time because they're not doing what we hired them to do. It's still part of the job and it's still considered hours worked. All right, so I know we've covered a lot in very little time. So let's just do a quick recap of some of the key points that I want you to take away with today around recruiting and hiring. So remember, when it comes to getting ready to post a position, you want to review those job descriptions. Make sure that the job descriptions and then that carries over into the job ad is going to accurately reflect the job duties. Stay away from those generic templates. If you need to refer to them or you need a starting point for inspiration, that's great, but you want them to reflect your position at your workplace. Also remember that the job advertisement needs to either include or omit certain information. So we talked about those pay scale obligations for employers with 15 or more employees. And then also, staying away from any ad copy that would demonstrate discrimination against a protected class. So we want to audit our job ads to make sure that we're compliant on both ends of that. And even if we don't have the pay scale obligation based on our size, we still need to be ready to provide that upon request. We want to stay away from any recruitment inquiries, whether it's in the application or the interview process, that are going to lead to information about protected classes, things like getting at their religion, disabilities, marital status, right? We want to stay away from all of that. Once we have a candidate that we are ready to make an offer, having that written contingent offer before we begin any screening, such as the criminal history checks, the drug testing, or medical exams. Remember, the timing of that is critical. We cannot do any of that until we have made that contingent offer of employment. And when it comes to criminal history checks, if we're going to revoke an offer due to their criminal history, remember, it requires a thoughtful, deliberate process. So we have to be able to articulate in each circumstance the reason that the offer needed to be revoked. The fact that somebody comes back with something on their criminal history report is not enough. we have to tie that to the position and we have to do that individualized assessment, give them that preliminary notice, give them the opportunity to respond before we make our final decision. And then lastly, again, just a reminder, because it's a big one that we see all the time employers engaging in, is sending them things to review and things to fill out before their first day. But we need to remember that onboarding activities, again, that is directed by you, and therefore it is considered hours worked. And we need to make sure that we are compensating for all of those onboarding activities. All right, so we made it. I know that was a lot, and I'm happy to take any final questions that we have.
Awesome. Thank you, Bianca. We do have a few questions in the chat, and I have a few consistent questions that have popped up. These slides, the webinar has been recorded, and so the recording will be available for everyone to see. We may email them out to you, or they will be on our site. They will have a YouTube link attached to it. So these slides and the presentation will be visible after this. So there's a few questions here, Bianca. One from Claudia. So for the hours worked, does it include if we ask a new hire to get their background check done prior to their first day?
Oh, that's a good question. So the way that the background check will usually work is you're going to get that authorization for them, right, to conduct that background check. And then there isn't really anything for them to do, right? You're essentially taking that authorization and you're running a check. You're working with your vendor or whomever to run that criminal background check on them. So that's not going to really take any time from them. But in the drug testing space, that does take their time, but they aren't yet your employee, so that time does not have to be paid because they're not yet your employee. So hopefully that helps. Again, I don't think it's going to be any time of theirs for the criminal background. It will be their time on drug testing, but we don't have to pay for it because remember, they're not yet our employee at that point.
Awesome. Thank you for that. Bianca, another question from Catherine. Does the time of hire pamphlet cover the workers' comp pamphlet for the new hires? I'm assuming that's what WC stands for.
Yes, yes, yes. That's exactly the one. Yeah, the workers. That's what it's that one because I included the numbers on there. That one I don't think has a specific number, but that should be the same. I think they're referring to the same thing.
Awesome. Claudia asked another question. Uh, we do have them. Okay, that was a statement. Thank you for that, Claudia. How much time do you have to do the background check? If you hired someone, but not do the background check right away, can you still do it later?
Yeah. So no. So you again, you have that narrow window really to do it. So this is where if you know you're going to do the background check, you want to do it again before it's contingent, the offer is contingent on that background check. So you'll want to let them know when is your first day, giving yourself enough time to have that background check, the results come back. And if some of this might be estimation, right? And so that's why I was saying you may need to adjust their first day, push it out depending on how long the results taking. I know back in the pandemic days, that was something that employers were up against. I haven't heard anything lately as far as long delays, but you'd want to work with the vendor and say, okay, how long does this typically take? Have a sense of that. The idea is that you get all of that back. You are able to go through any process before their start date. Or if for some reason it's not, then you push it out. Once somebody is your employee, we're much more limited in how we can just do a background check. If there's an overall change in management or there's a transfer in the company, right, to where now it's the new policy, then that may be a different story. But it's similar to drug testing, right? We're not just running criminal background checks on our employees just because we want to. So it's really in that hiring window once we've made that contingent offer.
Awesome. Thank you for that in-depth answer. So for the sake of time, it's 12 o'clock. I'm going to put a link in the chat. There are a few more questions there, but if you did not get your questions answered, please feel free to ask your question to us online. There is a link that allows you to submit a question. We check this regularly, and we are open to answering all questions that you may have. I don't think I can put the link in the chat. Okay, well, we will make sure that you get the link to ask any questions that have not been answered. Please flood us with your questions. We want to be able to answer all and every question that you may have around this particular great topic. And so, for that, I want to say thank you, Bianca, to the California Chamber of Commerce and the Small Business Policy Council for all of your hard work and dedication through this series. I look forward to doing more of these with you. There's a ton of information that you still have available for us. So please, all of you all who are participating today, thank you so much for coming out. Please visit calosba.ca.gov, the California Chamber of Commerce's site, to get more information about the topics that are coming up, the that have previously been discussed, because there's a wealth of knowledge for you and your small business to be successful. So again, have a great weekend. Happy Friday. Bianca, thank you so much. You're amazing. And I hope you have a happy Friday as well.
Thank you so much. Thanks, everyone.
Thank you.